Welcome to LawSplained Simply, a channel designed for you to educate you and empower you when making litigation decisions. This is episode 2, and my name is Ruzba Hosseini. I'm a partner at Cambridge LLP in Toronto, Ontario, Canada. And we are a law firm that on a day-to-day basis helps clients with their litigation needs. In this episode, we're going to talk about how a lawsuit is commenced and the types of lawsuits that are generally commenced in Ontario. So let's get to it. So there are two types of lawsuits typically in Ontario. The first is called an action, and the second is called an application. So what's the difference? Well, an action is commenced by a statement of claim. And a statement of claim is a document that typically your lawyer will prepare that includes the relevant facts and the elements of each cause of action that you are seeking to pursue in the litigation against whoever it is that you're suing. Actions are the most common type of litigation process that is commenced in Ontario. And actions require two things. First, they require a trial, and they require discovery, which we will discuss shortly. And the typical matters brought by way of action are contractual disputes, personal injury disputes, wrongful dismissal claims, professional negligence claims, and other tort claims, and most property disputes. What's an application? Well, an application is used when you require a court order based on written evidence by way of an affidavit. Applications are commenced by what's called a notice of application. And applications are intended to be summary proceedings. So what typically happens is you will commence the application by notice of application. Then you will serve on the other party or parties the notice of application and the affidavit evidence that you're relying on. The other party or parties who are responding to your application will serve their own affidavit evidence in response. And then there will be cross-examinations on those affidavits outside of court. And the typical matters brought by way of application are judicial reviews, passing of accounts of an estate trustee, partition and sale of a property, and any other matter that is authorized to be brought by way of application by statute. So what are the stages of an action? Well, the first stage is the pleading stage. And the pleading stage is where you serve your statement of claim, and the other side will then serve their defense to your statement of claim. And once that stage is complete, the proceeding will automatically enter the discovery stage. And the discovery stage is where you will gather up all your documents, all your pictures, all your videos, and you will send it to the other side, and the other side will do the same. In addition to that documentary discovery, which I just discussed, there will also be oral discovery, what we call examinations for discovery, and what in the US they call depositions. And that's where each side will have the chance to question the other side about the evidence that they have exchanged. And once the discovery stage is complete, the final stage is trial. And that's where all of that evidence will be put to the judge. And you may be cross-examined. You will give evidence on all those documents, and then the judge will make a final decision. And you'll see that applications are very different, because while the proceeding is commenced by a notice of application, once that's done and the affidavits are exchanged, there is then cross-examination on those affidavits outside of court. And so what happens in an application that's different than an action is that all the evidence that you're relying on, that you want the judge to see, is first put into your affidavit, and the responding parties will do the same. And then that cross-examination doesn't happen before a judge. It happens outside of court, and a transcript is obtained of those cross-examinations. And when all of that is done, the transcript of the cross-examination and the affidavit evidence is put before a judge, and then you're given the opportunity to make arguments based on that evidence before the judge. And then the judge will make a decision. And that decision is made at a hearing. So the final takeaways. What is an action? Well, an action is for matters involving factual disputes that require a trial and that require discovery. An application is for matters involving legal interpretation, statutory rights, or where the facts are seriously not in dispute. Thank you very much for joining us on this second episode of LawSplained Simply. Don't forget to join us once a month where we will be discussing new topics that you may be interested in litigation. And don't forget to like and subscribe and comment if you wish to do so. And I look forward to seeing you again next time. Bye-bye.